Hi, everyone. My name is Grace Shaw. Welcome to my presentation, Privacy 101 for Emerging Companies. I'm an associate at McMillan LLP. My practice involves a lot of work in the administrative law space, but in the regulatory spaces of transportation and environmental regulation. But I also do a significant amount of privacy-related work, which is why we are here today. So, to start off with, I want to do a bit of an overview of what we're going to talk about today. Number one is the legal perspective of privacy. And so this can be a somewhat complicated topic because, as we will go over, there are a lot of tentacles to the octopus that is privacy law in Canada. But we're going to try and keep it high level and sort of go over the different regimes and which ones may apply to, or most likely apply to, your business. Next, we're going to go over a principled approach to privacy and data compliance. So once we kind of give an overview, a lay of the land of the privacy laws, we're going to talk about the principles that are embedded in all of the legislations across Canada, even though they can vary slightly from jurisdiction to jurisdiction. And those are the principles that you should hold on to and keep in mind when you are building your privacy compliance program, because they are universal within Canada and foundational to any strong and compliant privacy program. Then we're going to talk about breach reporting and kind of do a status update of what we've learned since breach reporting became mandatory for some private sector jurisdictions in Canada in 2018. We're going to do a bit of an overview of CASL, or Canada's anti-spam legislation, which sort of falls within the privacy umbrella, if you will. Then we're going to talk about common privacy pitfalls for startups that I've certainly noticed across my years of practicing in this area, and we're going to talk about ways to avoid those pitfalls. And finally, we'll finish off on potential changes on the horizon that we're seeing in the privacy law space. And if you have any questions, please feel free. I understand that we're typing them into the chat bar side, and I'd be happy to answer them. Okay, so with that, let's get started. Okay. Yes, great. So on this first slide, why are we talking about this topic today? And I've sort of narrowed it down into three bubbles that sort of ground us in the privacy environment that we're living in. The first is just that privacy and data protection issues are increasingly arising in a variety of contexts. And it's almost hard to keep up with how many ways privacy is entering into the corporate lexicon, but also just kind of personally and from a consumer standpoint. One big way that we've seen in the last few years is cloud computing, which is sort of a general term for the delivery of a variety of different services over the internet. And while cloud computing is a great way to expand your organization, it has a lot of tools for data processing, data storage, retention, accounting, communications, customer service. It really makes a lot of these things accessible, especially for smaller businesses who might not have the infrastructure to have their own servers or networks or things. So cloud computing certainly isn't going anywhere. But there are, however, fairly significant privacy implications associated with using a cloud provider. So we're going to talk a bit about that and put that into some context. Additionally, COVID-19 has created a whole host of privacy concerns and considerations, putting aside some of the more obvious ones like contact tracing and sort of mobile phone tracking, things like that. Putting that aside for a moment, just working remotely, doing what I'm doing now, what we're all doing, and kind of doing business online and interacting online is really becoming the new normal. And with that, there's an obvious increase in, all forms of cloud computing, information sharing, data storage, and companies have needed to evaluate their privacy policies, procedures in light of this and respond to those changes. The next bubble I have there is importance to customers and investors. And I think that on an individual level, the value of people's data is becoming very well known in the public now. And so there has been an increased awareness of the right to privacy on an individual level. It's no longer really just an abstract concept. I think it's fair to say that it's becoming more front of mind for a lot of individuals and that, as well as investors and companies. So what we've seen is a robust, proactive privacy policy is really just good business. And it's a way to differentiate your company from others in the current climate. And that sort of all feeds into the third bubble I have there, which is regulatory oversight, guidance, and an indication of increased enforcement on the horizon. You know, having a privacy policy and a privacy program is part of the law. It's not optional if you're handling personal information in a commercial context. So that's always important to keep in mind. It's obviously a big reason of why we're talking about this today. We've also seen a global trend towards increased privacy or an expanded sense of privacy compliance. What comes to mind, which some of you might have heard of, is the EU's General Data Protection Regulation, or the GDPR. That came in a couple of years ago and kind of took the privacy world by storm because Canada has a more principles-based approach oftentimes to privacy law, whereas the GDPR is extremely detailed, very prescriptive, and very widespread. So that kind of really indicated a more global trend towards increased privacy protection. We've seen increased laws in California with the California Consumer Privacy Act of 2018, which is of course localized to California, but again, shows the trend. And then in Canada, in 2018, we had the introduction of mandatory breach reporting for a lot of private sector companies. And in 2019, our federal government started speaking about the Canadian Digital Charter, which does not have the force of law yet, but it did show that one of the government's priorities is increasing its enforcement powers, perhaps overhauling the legislation, and generally sort of bringing our privacy laws into the present day. Because they actually are, although our regulators try and keep them up to date and kind of keep us up to speed with all the changes. One of our main privacy laws, PIPEDA, which we'll talk about in a second, came into force in 2001. And, you know, did people even have cell phones in 2001? We don't know. So, I mean, that's something to keep in mind, that there's a lot happening in this space. So with that, let's dig into the legal perspective. So like I said earlier, Canada has a complex legal framework governing privacy. I've listed all of these different bubbles just to kind of give you an idea of what we're dealing with when we're talking about privacy legislation. It is certainly not one thing, but starting from the left, which is probably going to be most pertinent to our audience today, are the private sector legislations. So that's PIPEDA, the Personal Information Protection and Electronic Documents Act. That's our federal act. And then substantially similar provincial legislations. We have those in BC, in Alberta, and in Quebec. We'll talk more about the interaction between PIPEDA and the provincial laws in a moment, but that's kind of the private sector realm. Moving on to public sector privacy legislation, which applies to public bodies. Not probably as relevant to today's discussion. However, I work with a lot of companies who contract with government service providers to provide their service, outsourcing, for example, and government or public bodies can pass along their obligations to service providers. And you could be considered a service provider under the legislation in some circumstances. So public sector privacy laws are an important thing to be aware of. Next, we have health sector privacy legislation. And every province other than BC and Quebec has one of these. This is specific to personal health information. It has a lot of more, I would say, specific restrictions. And obviously it's a more narrow focus. However, and has traditionally applied to hospitals, doctors, clinics, things like that. But we're seeing an expansion of these laws, particularly in the wake of COVID-19 and the practical need, the reality, the urgency, the efficiency of collecting personal health information on a grander scale. So also something to be aware of. And then privacy torts, these are private actions. They can arise from the statute or they can arise from the common law. The courts have been recognizing these kinds of torts more. Intrusion upon seclusion, basically snooping, and publicity given to private life. And then there's our last bucket there, which is unique provincial laws. So for example, the Quebec Civil Code. I'm not going to talk about the Quebec Civil Code today, but just to give you, again, an idea of the privacy landscape. What I am going to focus on today are two legislations in particular, PIPEDA and BC PIPA, which are the private sector legislations, as I was saying. And we are in BC. And so these are probably going to be the ones that I'm thinking you're going to be interacting with the most. Starting with BC PIPA. So BC PIPA applies to provincially regulated private sector organizations in BC. This is not limited to commercial activities. It applies to every organization, so not-for-profits and charities included. This is because BC, as well as Alberta and Quebec, have substantially similar legislation to PIPEDA. One thing to note here is that BC PIPA does not apply to commercial trans-border information flows. That is PIPEDA. And so this is where things can get a little bit sticky, because this is where you might be actually subject to, or in all likelihood, if you operate a business within BC, are subject to both regimes, BC PIPA and PIPEDA. So I'll move on to PIPEDA now. PIPEDA applies to all provinces without substantially similar privacy legislation, so that doesn't include BC. It applies to the collection, use, and disclosure of personal information in the course of a commercial activity and across borders. So for PIPEDA, it has to be it has to be an activity which is a commercial context. And it will also apply to any trans-border data flows. And so that's really, not to get too much into the constitutional why of this, but sometimes it helps me to ground myself in understanding why we have all of these different arms of privacy laws. And that's because the federal government has constitutional powers over intra-provincial and international trade, as well as jurisdiction over federal works, undertakings, or businesses in BC, like banks, airports, and things. So these are things where the federal government just retains jurisdiction no matter where the business is based. And so as soon as data crosses a border, you're into federal territory, i.e. PIPEDA. So an example of a trans-border personal information flow would be using a national credit reporting bureau to run a credit check on somebody. That information is now crossing a border, to send customer loyalty information to your cloud storage provider who might be located in Delaware. These are all sort of where you're entering into that trans-border realm. So like I said, in today's world, and if you operate in BC, you're likely going to have to comply with both regimes. So so that's kind of a bit of an overview of the legislations that we're talking about here. Moving on. So oversight, BC PIPA is regulated by the Office of the Information and Privacy Commissioner of British Columbia. PIPEDA is regulated by the Office of the Privacy Commissioner of Canada. But like I said before, even though there are differences between these legislations, they are substantially similar. They're grounded in the same principles. And so we'll often get a lot of helpful guidance from the OPC that has been issued in conjunction with the other private sector privacy regulators in different provinces, to try and be a little bit more harmonious in their approach to how they're going to apply their privacy laws. So we'll be referring to the OPC a lot today. Some of my materials do, but that doesn't mean that they don't apply to BC PIPA. Just means that they're an OPC document. Exceptions, again, on the legal perspective still, to these legislations is if you're using the information for a journalistic, artistic, or literary purpose, for personal or domestic purposes, and public records that are publicly available. Oh, we should also probably talk about what is personal information. There is a definition of that. It's pretty much consistent across Canada. And generally, it's any information about an identifiable individual, but does not include business contact information. So if I give you my business card and you email me in that context, we're not considering that personal information. But I underlined identifiable individual because it's not just written recorded information. This video that I'm making now, if it was muted and just my likeness on this video, that's personal information because I'm identifiable by it. So the definition of personal information is quite broad. I mean, it can even include signatures, different types of video or pictures, just anything that is your likeness. And still in the legal perspective, the risks are high. There is a misconception a bit that privacy regulators in Canada don't really have any teeth. So privacy complaints maybe don't really go anywhere, nothing really happens. And while I do think that it's a pretty commonly accepted fact that our privacy regulators' powers could be strengthened in comparison to the rest of the world, i.e. Europe, which has staggeringly high fees for violations. Privacy complaints do, especially now, carry with them a big potential risk, not only monetarily, but the privacy commissioners can publicize reports of their findings, and that can lead to very bad publicity, kind of showcasing an organization that the OPC does not feel is complying with the law. Recently, the Competition Bureau has stepped into the privacy enforcement space and has fined a company in Canada $9 million for having what it considered to be a misleading privacy policy. So the stakes are getting higher and higher. Also, class action litigation has become quite prevalent now, especially when data breaches can be extremely widespread. That's kind of the nature of them. They're very hard to contain, so they're really prime for a lot of litigants to potentially band together and proceed with a class action. So now I think maybe, hopefully, we've discussed enough of the law. We can move on to a principled approach. So since these laws do vary across provinces and sectors, when in doubt, I wanted to go over the 10 fair information principles. These are literally part of the schedules in PIPEDA. So these form part of the law. They are also embedded within BC PIPA, Alberta PIPA, and they are something to keep in mind when you're creating your privacy program, because it really is important that privacy is proactive and that it engages all members of your organization. This is often called privacy by design, and it is a framework about proactively embedding data protection and privacy into the operation of your IT systems, your network infrastructures, and your internal business practices. So we'll go over them now. There's 10 of them, and we'll talk a bit about that. So the first principle is accountability. So we are responsible for the personal information that is within your custody, control, and possession. It doesn't matter if you collect information and then transfer it to another party. Even if it's not in your physical custody, you are in control of it and you still remain accountable for that information. So that's really important to remember when you're collecting this information. Under the legislation, you have to implement policies, procedures, and training to ensure compliance and to demonstrate compliance. And somebody within your organization should be designated as a privacy officer, somebody that is specifically accountable to your customers or your users who can answer questions about your privacy compliance. Next is identifying purpose. There are things that you need to consider when you go about collecting personal information. Why do we need it? What are we going to use it for? You need to document the purposes for why you're collecting information, and you need to inform individuals of those purposes, because that is the basis of how you're going to get consent. You can't get consent unless you identify to the user the purpose for which you are using it. And so that purpose needs to be clearly defined. And that'll make more sense in my next slide, which is consent. Consent is really the pillar of privacy law in Canada. It's one thing that actually differentiates us from the GDPR, for example. Consent is just the basis for how we regulate privacy in Canada. So knowledge and consent are required to collect, use, or disclose personal information. And explicit consent is the general rule. Now, the OPC has issued a lot of guidelines on consent, because what really we've seen is that consent has been something where people just sort of maybe consent and they don't really understand what they're consenting to, because everything is so fast-paced now. You want access to an app, you want to download something quickly, and so you consent. Or, the details of what you're consenting to is sort of buried somewhere on a website and you don't really know what's going on. So meaningful and informed consent is the requirement, which makes companies have to go one step above just having something somewhere on their website. You really need to explain to people in clear layman's terms what it is you're collecting their information for, what you're using it for, who you're going to disclose it to, in order to make consent meaningful. And that's been something that regulators have really focused on in recent years. There is such a thing as implied consent. It still has to be informed and knowledgeable. It's only for non-sensitive personal information, where whatever you're collecting the information for is within the reasonable expectations of the individual. And so, for example, if somebody signs up to be a part of, to sign up for an account on your website, and they get an email that they've signed up for the account, it might be within their reasonable expectations that when using that account, you're also tracking their purchase history. That would perhaps be an implied consent scenario, but it really isn't black and white. The exceptions to consent are quite limited and narrow. So really you should ask your privacy officer or legal advice when you're considering whether or not to rely on implied consent, because it can be a little tricky. The next principle is limiting collection. So this is a really important question, because oftentimes we'll see companies collecting information in order to start a program, or in order to have a consumer sort of platform on their website, things like this. And they're collecting a bunch of information that isn't necessary to achieve their purposes. And that really only increases your risk, because now you're the collector of more information than you actually need. So just do not collect personal information indiscriminately. The amount of times I've seen forms where you're asking for people's SIN numbers and things like that. Why? Do you really need that? If you don't need it, you don't want that information, because it's highly sensitive. So do an audit of the amount of information you're collecting, the type of information, and try and limit it as much as you possibly can. And that goes into principle 5, limiting use, disclosure, and retention. Be very aware of what you received consent for to use the information, who you're disclosing it to, and how long you should keep the information. Particularly with who you should disclose it to, we've been talking about outsourcing a bit earlier to third parties. Persons acting on your behalf, for example, a payment processor or a payroll administrator, something like that, you're allowed to outsource those functions, but you remain accountable for the information that's transferred. So you want to be very careful about the due diligence that goes into selecting third-party processors, and to ensure that you have adequate contractual protections in place so that you can be sure that these third parties are giving an adequate amount of protection that you are required or obligated to ensure is happening. Accuracy, so information has to be kept accurate, complete, up to date for the purposes it's being used. Safeguards, these include physical, organizational, technological safeguards. This is oftentimes considered sort of an IT head of privacy, but while there is obviously IT aspects to it, it really is fundamentally as well an organizational issue that you need to be aware of, because safeguards include access procedures, ensuring people aren't accessing information that they shouldn't be, that the person disclosing the information didn't consent to, ensuring people keep their passwords up to date, ensuring that adequate encryptions are on USBs, ensuring that people lock up their laptops. These are not just IT problems. These are things that are really fundamental, widespread across an organization to ensure that the adequate safeguards are in place. Of course, you have to consider the sensitivity of the information. The more sensitive it is, the higher the security should be. And information should be collected throughout its life cycle until its destruction. And so having those kinds of procedures and plans in place is very important. Openness. You have to be open about your policies and practices regarding personal information, and this information must be readily available and in a form that is generally understandable. A really good privacy policy is one way of showing this, with the contact information of your privacy officer. Individual access. Okay, so individuals are entitled to access their own personal information, to correct and update it, and get information upon the existence, the use, and disclosure of personal information. And this is why it's very important to keep records of what you're collecting, when, why, because if somebody wants to ask what's going on with the information that you've collected, you have an obligation to tell them, with some certain exceptions, but they're very narrow exceptions. If disclosure would, bring harm to a third party or something like that. So you should keep these rights of individuals in mind. And finally, challenging compliance. So individuals may be entitled to challenge compliance with these principles and can file complaints. They can, go to the media. They can do a whole bunch of things. So it is really important to keep these principles in mind. And always consider reasonableness. Reasonableness is a really good word to think about with privacy. It's the overarching theme of all sort of privacy laws, like what is reasonable, what is a reasonable amount of information to collect, a reasonable time to retain it, a reasonable disclosure to a third party. So it really can reduce the risk of complaints and litigation if you approach your privacy program with reasonableness in mind. And so that is the principled approach. So now we'll get into more tangible topics, such as breach reporting. So public and private sectors have obligations to report breaches. Now, BC PIPA does not have breach reporting, mandatory breach reporting. However, PIPEDA does. Ever since late 2018, they have mandatory breach reporting for private sector organizations. So the threshold for reporting a breach is a real risk of significant harm. And there are notification requirements when that threshold is triggered. You need to notify the individual, you need to notify the OPC, and in some cases, for example, if there was a theft of a laptop in the middle of the night from a car, you have to notify the police so that they can launch an investigation. So it really triggers a whole host of obligations when you kind of engage with the breach reporting regime. There's also record-keeping requirements. So you should always keep really great records of anything related to privacy, especially breaches. But these record-keeping requirements, when you're in the breach reporting realm, become quite significant. So what have we learned? We've learned since 2018 that the majority of breach reports that we've seen involved some sort of unauthorized access. So here's a little graph from the OPC of the types of breaches that they've seen since November 1st, 2018. Unauthorized access is the vast majority. Then you've got accidental disclosure, loss, and theft. So unauthorized access is an interesting one to think about with breaches, because a breach is not just a nefarious actor hacking into your systems or a thief stealing a laptop. Unauthorized access can be completely innocent intentions. It could be human error, somebody accidentally opening and disclosing a file that they shouldn't. It could be employee snooping. There's a misconception that employees, if they work in an environment, automatically have a right to whatever information is within the company. And that's not true under privacy laws, because access needs to be limited, disclosure needs to be limited. And so these types of breaches, which could be as easy as, leaving a unsecured thumb drive on the bus or something, these are breaches. And then you have to engage in this assessment of, well, was there a real risk of significant harm? What was that information? Where did it get left? Am I within the breach reporting realm? So it's really not just bad actors that we need to be aware of, although bad actors are getting increasingly sophisticated with phishing scams and things like that. I know we're all very, very aware of these now. But from an internal standpoint, the unauthorized access is definitely something to be aware of when you're thinking about your breach reporting regime. We've learned a lot of lessons over the past couple of years with breach reporting. I've been a part of a number of breach investigations on behalf of clients. And here are some of the things that I think are really must-knows for any organization that handles personal information, because the risk is really never zero. We are all vulnerable to some kind of breach. We are all vulnerable to some sort of human error. The best we can do is take proactive steps to avoid having to react immediately on the ground. Because when we've seen that happen, where a breach occurs and there's no plan, the results can be kind of catastrophic, and it can get extremely expensive to try and deal with that after the fact. So here's the things to take away. Know what information you have, where it is, and what you're doing with. Understand your vulnerabilities from an internal perspective. Know where your weak points are, things you have to focus on. Know the vulnerabilities in your industry, i.e. breach trends. A lot of trends, particularly certain scams, for example, tend to target specific industries. So that's something that you really want to be aware of. The fourth one, which I can't stress enough, is employee training. Really familiarizing staff with what's allowed, what's not, what are the signs of a phishing attack, implementing access control so that things are password protected, so that it really reduces the likelihood that somebody's going to accidentally access some information that they shouldn't. And then finally, implementing procedures to identify and deal with breaches. This will definitely save a lot of headaches down the road. So next up, we're going to talk about CASL, Canada's anti-spam legislation. So CASL is intended to stop spammers. So it was started with the idea of stopping kind of junk mail, things like that were really infiltrating people's inboxes. But it does start with a broad prohibition on commercial electronic messages, or CEMS generally. It's not just limited to anti-spam. It also addresses installing computer programs and altering data transmissions. Once again, the thing about CEMS is that consent is key. The focus is on a consumer consent to receive a CEM. So when you enter a website and they say, oh, do you want 15% off? Then just please sign up for our email list. That's probably due to CASL, because they need your consent to send you commercial electronic messages about advertisements, promotions, sales, new products. These are all commercial, these are all chems, and they need your consent to do that. So they're enticing you with a one-time 15% off email. And you know what? It can work sometimes, but something to be aware of. Unlike most other jurisdictions in the world, Canada requires positive opt-in consent. You have to say, yes, I agree to receiving commercial electronic messages. There's also the business card rule, which is that there's implied consent to contact people with messages related to their business address. So if I hand you my business card and you send me an email in that context, that's likely not covered by CASL. So where are we now? Okay. Common privacy pitfalls. These are things, like I said, that we've noticed over the past couple of years. And we just wanted to talk about them today and ways to avoid them. One is we're a small company. Well, in privacy law, size doesn't really affect, or size of a breach, for example, does not really affect what your obligations are, for example, to report a breach. There's nothing about scale. It's just whether or not there's a real risk of significant harm. I've worked with companies where only one person's data was compromised, but it was very sensitive data. And it was through a nefarious, a bad actor. And so that triggered the breach reporting obligations because that's what the test is. So it doesn't matter the size of your company. You'll still be under the umbrella of privacy laws. So that is a misconception. If you're handling personal information, then you're within the privacy realm. Next one that I hear all the time is that GDPR compliance is Canadian compliance. Well, we're compliant with the GDPR, so we should be fine in Canada. Not quite. Although the GDPR does have kind of a reputation of being the gold standard of privacy, there are some material differences with Canadian privacy. The main one of the main ones is consent. The consent regime is not a part of the GDPR. They have something called a legitimate business purpose exception that businesses can use in order to process data. We don't have any such exception. So if you're relying on a legitimate business purpose to process data, that's not a thing in Canada. So you still definitely need to make sure that you're complying with the Canadian privacy laws, even if you also have a GDPR compliance program for your European operations. Another one, a big one, is that, okay, we have a privacy policy, so we're good. And that is unfortunately just not the case. Privacy needs to be, as I said, proactive. It needs to engage all levels of an organization. We spoke a little bit earlier about privacy by design, which is really a total framework for privacy that goes to IT systems, infrastructure, business practices. Having a privacy policy, a good privacy policy, is really just the beginning. And it doesn't involve just copy and pasting, a competitor's privacy policy and saying that this is ours. Like we spoke about earlier, a misleading privacy policy led to a $9 million fine earlier this year. So a privacy policy is probably going to be an iterative process within your organization or with legal advice to really ensure that it actually represents what your organization is doing and that you are going to do what it is that you say you're going to do. So that is a very good starting point. The next is training your employees, explain authorized access, your informational and handling procedures, your retention procedures. The next is have a breach reporting program in place yesterday with clearly defined roles, with next steps on how to react when the inevitable happens, some sort of breach happens. If anything, even if it doesn't reach the threshold where you have to report it, you want to keep a record of it in case a complaint arises in the future or in case there was an unintended consequence of the breach. So these are things that need to be really embedded within all levels of your organization. Another thing to consider are privacy impact assessments, or PIAs. These are a process which assists organizations in identifying risks associated with new projects that involve the collection of personal information. Excuse me. They are required for most public sectors. So, for example, if BC Hydro wanted to start using SurveyMonkey, they would need to, which collects personal information, they would need to fill out a privacy impact assessment to assess the implications from all different aspects of using this program, and then identify weaknesses and vulnerabilities and things like that. So I've done plenty of PIAs for public sector clients, but we are seeing an increasing interest in doing these kinds of things in the private sector as a sign of good faith, of good business practice. They show accountability, they show proactiveness, and they also internally help issue spot when you're kind of onboarding a sweeping new program. So PIAs are something to consider. And really just generally, like most things in life, it's better to be proactive than reactive with these things. So having a privacy policy is not the end of the story. That's the lesson from that bubble. And we've talked about how when personal information gets transferred to a third-party processor, that's not the end of the discussion for you. You are still in control of that. You are still responsible. Do your due diligence and have proper contractual protections in place when you're giving personal information that you've collected to a third party. And then finally, privacy violations have a low financial risk. Not always, as we saw with the privacy violations earlier. And like I'm going to get into on my final slide, there's a strong indication that our privacy regulators will be getting more teeth in the future. So finally, changes on the horizon. In May 2019, the Canadian federal government released the Digital Charter. Doesn't have the force of law yet. You can Google it and look it up online to learn more about it. But it really is, there's been a long push in the privacy community from privacy professionals, from regulators, and from the public to update our privacy laws, because we've done our best with what we have. But like I said, PIPEDA was enacted in the early aughts. So given the kind of global trends we've seen and what the government has said, these changes could be related to stronger enforcement, clear accountability for organizations, including hefty fines. So they do indicate that there is a more onerous privacy regime on the way. So really, keeping that in mind, it is a really good idea to get in front of privacy protections now to make sure that your organization is informed of its requirements, what jurisdiction it applies to, and kind of having a data governance privacy framework for your organization, because not only is it the law, but it's also great business sense now and certainly in the future.